Crypto Twitter is awash with the rumor of SEC Chairman Gary Gensler resigning from the regulatory agency. Pro-XRP attorney John Deaton commented on the rumors, saying a Gensler resignation was possible. A pro-XRP attorney John Deaton addressed reports of Securities and Exchange Commission (SEC) Chairman Gary Gensler's departure. While reports of Gensler's retirement is only hearsay, Deaton thinks the SEC chair will leave for political reasons. SEC Chair Gary Gensler, according to John Deaton, an amicus or friend of the court in the SEC VVs. Ripple litigation. Deaton responded to a widely circulated claim on crypto Twitter about the agency chair's whereabouts. According to Deaton, the impending election campaign might result in Gensler resigning from the SEC after the agency's crackdown on Bitcoin exchanges and initiatives in the ecosystem. For nearly 2 years, the SEC has been involved in a legal struggle with Ripple. The banking authority recently sued Binance and Coinbase, two of the major exchanges in the cryptocurrency sector. The regulator designated almost 6 cryptocurrencies exchanged on their platforms as securities, in the case implying that the exchanges were permitting the trading of unregistered securities, which is a significant infraction. Holders of XRP are awaiting a decision in the SEC CVs. Ripple lawsuit, according to Ripple Labs. According to Ripple Labs CEO Brad Garlinghouse, the summary judgment in the dispute will be issued by Judge Annalisa Torres by September. Pro-XRP lawyer Fred Rispoli predicts a decision in the SEC CVs. Ripple litigation by August 10. Rispoli derived this from Judge Torres' prior summary judgment data. At the time of writing on Monday, the cryptocurrency was trading over 4,810 cents. While XRP holders await the outcome of the lawsuit and Ripple's next actions, the cryptocurrency maintains its positive upward trajectory. As the cryptocurrency industry awaits the outcome of the lawsuit launched by the United States Securities and Exchange Commission, SEC, against Ripple, a pro-XRP legal expert has presented more reasons in favor of the blockchain firm's side of the legal fight. Indeed, in a tweet on July 2, lawyer Bill Morgan joined a discussion with well-known XRP community member Meister Huber and former SEC enforcement lawyer Mark Fagel, in which the former asked why the regulator filed no injunction at all if Ripple did anything nefarious or even illegal besides selling unregistered securities. What is the point of protecting investors if Ripple can continue to pursue what the SEC considers to be clearly illegal and damaging to investors for years after the lawsuit is filed? He said. Shouldn't the SEC have made an attempt to apply for this for the protection of investors? Furthermore, he said, the SEC would need to show how there is an investment contract when ODL customers who don't invest in the token and don't expect profits to transact the XRP within seconds for fast, cheap cross-border payments, not investments. Previously, Feinbold reported on Morgan sharing his thoughts on several seldom-spoken neighborhood concerns. Judge Phyllis J. Hamilton of the U.S. District Court for the Northern District of California has granted class certification in the class Action Lawsuit Zakhanov EC. Ripple Labs in. At a critical point for XRP investors, the main complaint revolves upon Ripple's failure to comply with federal and state rules by failing to register its digital asset, XRP, as a security. This decision allows a large number of XRP purchasers to file securities lawsuits against Ripple, its subsidiary XRP, Ezio Bradley Garlinghouse, the last court date in the XRP investor class. Action case against Ripple was 2 months ago. Bradley Sostek, the main plaintiff, filed a request to assemble a class of global XRP owners who purchased, still hold, or have sold XRP at a loss. Despite Ripple's international presence, this order affirms the right of us investors to take legal remedies. Defense attorneys successfully argued that the litigation should be limited to us investors. Judge Hamilton acknowledged the changing legal situation around cryptocurrency in this complicated legal sector. She emphasized the difficulties that different countries face when classifying digital assets, emphasizing the importance of allowing individual jurisdictions to enforce their cryptocurrency regulation. She added, This ruling marks a significant step forward for the lead plaintiff and his legal team, who allege a loss of $118,100 after selling XRP in 2018 due to Ripple's misleading claims about the token's security status. This opens the door for other XRP investors to join class action and seek compensation for their alleged losses. The defense attorneys for Ripple and Garlinghouse contended that class members had differing opinions on XRP security status, which they believed would lead to strife within the class. Judge Hamilton, on the other hand, dismissed this argument, indicating that any objections could be resolved through the regular opt-out procedure. Sussman Godfrey's Nick Spear expressed pleased with the court's ruling as the case moves forward. A Ripple spokeswoman emphasized the court's rejection of a worldwide class and the significance of allowing other countries to regulate cryptocurrencies independently. The court's willingness to wait for the outcome of the SEC Ripple case before proceeding was also noted by the spokeswoman.
The SEC Ripple Labs court fight is one of the most high-profile cases, and as the industry awaits the decision, a lawyer anticipated the likely release date based on Judge Annalisa Torres' summary judgment ruling trend. Pro-Ripple lawyer Fred Rispoli said that the court's verdict in the continuing legal dispute between the Securities and Exchange Commission and the blockchain and software startup Ripple Labs might be released in August. The lawyer highlighted that 60 of the federal judge's rulings came between 146 and 330 days, with the judgment announced in an average time of 249 days. Using statistics related to the motion summary judgment of the United States District Court for the Southern District of New York Judge Annalisa Torres, who is handling the case. Based on these figures, the decision should have been issued on May 21, the 249th day after the original application for summary judgment was filed on September 17, 2022. However, it is no longer valid since that month has passed with no news from the court. Rispoli also hinted that the 330-day rule might be implemented in the SEC Ripple Labs case, and if that happens, the court's decision is expected on August 10 of this year. 60 of rulings are issued between 146 and 330 days, which is 249 days from September 17, 2022 to May 2023, and 330 days from September 17, 2020 to August 10, 2020, and 330 days from September 17, 2023. I may be getting the best birthday present of my entire life, the lawyer remarked, adding, peas, or the worst birthday present ever, either of those two. Rispoli's prognosis is a tad early in comparison to another pro-Ripple lawyer and crypto law creator John Deaton, who earlier projected using statistics that Judge Torres' decision may be issued on September 6. Deaton utilized Judge Torres' 6-month timescale finding on the Daubert motion in the Ripple Labs litigation on March 6, arriving at the September 6 date. She decided a case in which her summary judgment decision came 6 months after her Daubert decision. So if her Daubert ruling was made on March 6, it would be September 6 6 months later. Deaton said in a live video. Ripple Labs CEO Brad Garlinghouse has previously said that the continuing legal struggle is coming to a close and that the verdict might be issued in weeks.